come over here at least so we don't delay it any farther. So I'm Steve Yoder. I chair the County Planning Commission here. We've got a couple of our Planning Commission members here. We've got Bob Miller here, who's a member of the Planning Commission. We've got Tom Nixon, Dale Carlson, and Black. There we go. We got quite a few members of the commission that I have to remember. Then we have Commissioner Lawton over here too as well, that sits on the commission here. So we're happy to have you all here. We're going to have Mr. Hall here, who's going to present on the right to farm, and a lot of questions that go with that. So I will note, we've got the camera there. If you have to stand up, go behind it. That way it doesn't block the viewers that are watching it there. So we got plenty of snacks up here if you want to do that. So I'm going to let Paul take it away. Since U5, he has worked for Michigan State University in government and public policy, community and economic development. His graduate studies were done at Michigan State University, and he chairs the State of Michigan Farm Market Campus Committee. So plenty of resume there, so take it away.
Thank you. Well, welcome everyone. The first thing I'm going to do before I do anything else is apologize for my voice. It is a little crackly. It's been like that for about 2 months. I got sick a few months ago, and it's been very slow coming back. First time I've ever had this in my life for more than a couple of days. So if you need me to repeat something, please do. If you need to ask a question, please do. If it's something we cover later on, I'll push it off. If not, I'll answer it. And I will also stick around at the end for a lot of Q&A time as well, as much as you need. So I'm here to help. Again, my name is Ryan Coffey Hope. Thank you for the introduction. And my official role with Michigan State is Government Public Policy, Community and Economic Development. But I've done a lot of research over the years as well. I've done research, a lot of ag research related to ag business, looking at employment needs for food processing and food production side in West Michigan, down by us in the Fremont area, so Muskegon County, Leelanau County, Michigan County, that region. That work we've done for the Department of Ag's chair here in the state of Michigan. We also did it for a former governor as well. I've done work on national parks in the Great Lakes region, some research there. I've done research for the Attorney General's office here in the state of Michigan many years ago as well. And I've even actually done research that went all the way to the prefect of the Congregation of the Doctrine of Faith at the Vatican, who was Cardinal Ratzinger at the time, who later became Pope Benedict. So anything you've ever dealt with in township, county, state, or federal government, those politics are nothing compared to church politics. I mean, it's a whole different world, I will say that. I do a lot of community service within my role as well. I chaired economic development for many years in Leelanau County. I just recently stepped down after serving that for several years and transforming the organization. I serve on 2 different hospital boards for Spectrum Health. I'm actually the vice chair of one of our hospital boards at Gerber. I sit on the Community and Economic Development Committee for the Fremont Area Community Foundation. And I also serve on the State of Michigan's Natural Rivers Review Board. So if you're aware of that, there's several rivers that have natural river designation in the state. They have additional zoning rules that go with it. I chair the White River Review Board in West Michigan, and I also sit on the Pure Marquette River Review Board. And as was mentioned earlier, and I think the main reason I'm here tonight is I'm the chair of the Farm Markets Camps Committee. We'll talk about what camps are if you've never heard them, but it's through the Department of Agriculture here in the state of Michigan. What I want to do tonight is spend most of the time talking about the right to farm. It's where there's a lot of confusion across the state. There's a lot of nuances that I can address tonight. And I'm going to spend a lot of time talking about right to farm and GAMPs and how they work, how they don't work, and some recent conflicts that we see cropping up all over the state. I will also spend a little bit of time near the end of the presentation talking about planning and zoning for agriculture. I was asked to address that kind of as a follow-up to right to farm to see, where is we as a community? If we want to embrace agriculture as part of our community, we want to preserve it, encourage it, enhance it. What is it that we can do from a planning and zoning perspective as local government officials to make that happen? So just out of curiosity, when you did your introduction, I heard several county. For the people in here that are not part of the county government, are how many of you are some type of township official? So good amount. How many of you are farmers? Okay, so we have a really good mix in here tonight. So good. Thank you. So I want to start with the Right to Farm Act. The first and most important thing that you need to understand about right to farm. It is very rarely ever black and white. There is a whole lot of gray, and there are many things that have not yet been adjudicated through the courts. We will talk about one of those that was recent in your county, Leelanau Township. I'll mention that case a little bit later on when we talk about some of the recent conflicts and how some of us have addressed those issues at the state level. But you always don't get the answer you want. Farmer calls up, a township official calls up, here are the facts. You work through the facts. Well, I can tell you, this, and this item, they're right to farm, open and shut, clear as day. These other two items, they're not. They're locally zoned, they're locally controlled. This other one, I'm not sure. We might need more data. Maybe it hasn't been to court and there's some gray area that we need to work out, but we can give you a good estimate. And so when I work with people at UNDARD, Michigan Department of Agriculture, they have a right to farm division, or I work with Michigan Townships Association with their attorney, or I work with Farm Bureau. They have a right to farm, a gentleman there that handles right to farm issues as well. We talk through these. Okay, we're in communication sometimes multiple times in a week because these cases are more frequent. You see them locally, we see them statewide, and you see a lot of overlap. And so we talk through these, and from an educational standpoint, I actually get people turn to me a lot from these organizations for guidance because I can provide an educational perspective. So right to farm, they've got a lobbying, right? They lobby for certain, they can only go so far. MDARD has a silo they operate in. Here's what the state laws say. They can't go beyond those borders, right? This is where they have to operate. MSU, we can provide a broader educational approach, and we can talk you through some of these things. The only thing I will say is we are not licensed attorneys. So if it comes down to it, you need to talk to an attorney, either a township or a farmer. You talk to that individual if you think you need. And we'll always leave you with that advice. So the Right to Farm Act in Michigan was established in 1981. Every state in our country has some form of right to farm protection. They have a law. They're a little different from state to state. But what they do is they protect farmers against nuisance complaints. Okay? Now, nuisance, I'm going to read this definition. It's very short, but it's from the Act. Nuisance in right to farm is a substantial and unreasonable interference with the use or enjoyment of land. So it could be things like noise, pollution, odors. Those sound pretty common for those of you that raise their hand as farmers. We hear a lot of that, right? Well, they just put manure down, it stinks. Well, how long ago did they put it down? Well, they put it down yesterday. Well, if it's been 2 weeks, we might have a problem because of the way the law acts in terms of putting that manure into the ground. But those are nuisances. The Right to Farm Act, when it was written very broadly, and it casts a very wide net to protect farmers. Okay? It didn't want to get so specific that says, well, you do it this way, or you have more cows than the other person. Right to Farm Act doesn't look at it like that. They look at management practices to limit the nuisance, okay, through the dams. And so right to farm is very broad. And you need to understand that broadness. To understand what qualifies for right to farm, you basically have to meet 2 standards. One, are you what we call a legal, are you a bona fide farm? Okay? So it's not my hobby farm, I have 2 pet horses, and I have a goat and milk for our house. Okay? It's, am I a business? Do I have sales? Okay, and we'll talk about the threshold of that later on. So, because if it qualifies as that, it's not one of the 2 standards. And are they selling a farm product? Okay? So it's got to be some type of farm product. Now, a farm product does not have to be the blueberry that you pick off in a basket. It can be a blueberry pie you make out of the blueberry that's on site. We'll get into that detail much later on as well. But the second big thing, are they following GAMS? We'll define what GAMS are. Most of you may already know that term, but are they following the GAMS, the rules associated with the Right to Farm Act? Okay? To understand the broadness of right to farm, some of the court cases we have, farmer put corn maze in as part of their farm market, as part of their operation. The idea is I come there with my children, we go through the maze, and then, oh, by the way, we buy a product right next door. That was found to be protected under right to farm. Okay? I think one of the most extreme cases was a case called Sexy Pheasant. There was a hunt club that hunted wild pheasants on open lands. The township took them to courts. They claimed right to farm. The township said, no, you're not growing a crop. The judge in that case ruled that the shooting of a pheasant is the harvesting of a farm product. Okay? Broad definition. Now let me rein it in and show you where you kind of hit the ends of that definition. We had a case with wood pallets. And an individual was building wood pallets on their property using wood from their property. They claimed right to farm, and the township tried to shut them down as a commercial operation or a industrial operation. And the judge found in favor of the township because the farmer admitted in court, and rightfully so, he was honest. He was asked, are 50% or more of the wood going into those pallets coming from on site? And the answer was no. It was like 20, 25%, the rest was coming off site. And that's going to be a limited operation if it's all on site, right? It's not like a crop where you're regrowing each year. You can only harvest so many trees and then you're going to have to wait till they come back. So that kind of shows you the limit. We'll talk about what those limits are and how they're defined as well. The sales. What defines a farm operation, a business? Okay, what's that threshold? Up until about 2 years ago, there was no good legal definition. We as experts banged our heads for quite some time around tables talking about this. The best we could figure out, up until about 2 years ago, was that there was buried in an old law back in the 1880s in Michigan, there was something about farming and agriculture and a threshold of $300 in sales. So we thought, if it ever went to court, that would be a reasonable assumption, okay? So if someone's selling 1 dozen eggs twice a year, and they made $8 on it, that's not going to qualify. That was kind of our thought. However, there was a recent case out in the Muskegon area where the judge basically indicated in his decision, and MDAR, myself, and Farm Bureau talked about this ad nauseum, and we're kind of shocked. We believe, based on the judgment of the judge, the sale of 1 egg may be enough to constitute a right to farm clause or claim. Literally 1 egg. Okay? Because there's nothing in the act itself that sets the threshold. He was reading it very much verbatim, and the indication coming out of that is, I know MDAR, and I don't want to speak for MDAR, but with this new knowledge, they treat some of their work a little differently in light of that judgment. So we need to be aware of that. It's a very broad, if someone's going to claim it, and they legitimately have a right to claim it, you need to be careful as a township. If it's someone that pets and they're just trying to claim it as to not get permits or to not, whatever it may be, then you have the right to use local zoning. We'll talk about those in a little bit as well, but you need to be wary. It's a very broad net. Now, I'm not going to go too much detail into what the Act says. You can read it. It's very short. It's pretty straightforward. The most important thing with the Right to Farm Act, since its inception or since its adoption in 1981 when it passed, is there was an amendment in 2000. Okay? The amendment explicitly, the state legislature, when they amended that act, explicitly preempted local zoning. Okay? When I say explicit, it says in there, local zoning preempted. Okay? The wording is in the act now. And the initial outcome of that, because many of these GAMs have some open, very broad definitions and open interpretations. We saw a series of case law from 2000 to 2005. And we actually had this, MSU took the lead on this, we put all the case law together. And you can see a pattern going from broad court decisions as time went on, building off of each other to a very narrow point, where you and I were business partners. And we had the money and the means, and for some reason we wanted to do this just for fun. We at that time could have went into downtown Grand Rapids, downtown Detroit, bought the biggest skyscraper, knocked it down, put a cornfield, put chickens in, okay? That was a little scary. There was a loophole there, that had unintended consequences. And so, in reaction to that, it was under Schneider's administration, he was governor. There was a lot of political push out of the Detroit area, southeast Michigan, to fix this loophole. And their issue was more backyard chickens issues. And so what they did is they put a Band-Aid fix on the games. They asked all the committees to basically put in 100,000 population threshold in the games. Okay? Anything over 100,000, any city over 100,000, they were exempt from these rules. How many cities in Michigan have 100,000 or more people within their city limits, probably? You don't need more than these hands. I think it's 7, 8 maybe. How many cities do we have in Michigan that have under that are cities? I know at least 500, if not more. I mean, it's a huge number. So this was a fix, a Band-Aid fix. That's what I call that. It wasn't a permanent fix. When I took over several years ago as the chair of the Farm Market Finance Committee, the director, or the chair of the commission, of the Ag Commission, pulled me aside and asked me specifically to try to fix this. The catch is we had to root our decisions in state law. Okay, we didn't want reference to local zoning because the state of Michigan doesn't want to have to come into your township and your township and your township and flip through 100 pages of zoning to say, are you in compliance with the answer? It's not going to work. So the state wanted it rooted in state statute. On top of this, we also had a 2018 Attorney General opinion here in Michigan that was specifically asked, and this will relate to your recent case as well. If something is addressed in the GAMS, then local zoning is preempted. And what that statement meant was if it's addressed at all, then zoning is preempted entirely. Okay? And so we took steps within our committee to actually address some of that. And I think it might get into that a little later, but if not, let me just mention what we did. One of the things we did is we saw some townships using their sign ordinance to not let a farm market go into their community. And a farm market down a dirt road is going to die if it doesn't have a sign, because who's going to find it? Who's going to know about it? And so we knew we had to allow for signs in the farm market. However, because of these opinions and the case laws that we've seen, similar to what happened to your case here recently, we knew that if we just allowed signs under the GAM, then a farmer could put up an 8x10 sign, blinking neon lights. You couldn't do anything about it. And so what we did with this understanding is we worked backwards and we said, look, you can have at least one sign. If the local zoning allows more, you can follow the local zoning. But you are allowed under right to farm one sign, minimum. But we actually explicitly stated, local zoning still controls all height, lighting, all the rest, setbacks. Because we didn't want that sign to become unbearable for the township. We didn't want to hand off the township as well. So we found kind of a happy middle ground. I want to mention what GAMPs are. Has anyone never heard of GAMPs before? Someone good. GAMPs stands for G-A-A-M-P, with small s. Generally accepted agricultural management practices. They are mentioned in the Right to Farm Act. So the Right to Farm Act says, here's how you get protection, right to farm protection, here's what it is, but you have to follow GAMPs. So the Right to Farm is a law, it's an act. GAMPs are addressed in that act, but then they're kicked to the Ag Commission to adopt them, and amend them, and update them, and create them. And so the Ag Commission has a committee for all 8 of them, I'll mention those in a minute, and there's a chair for each, and we meet once a year and review them. Some years we don't make any changes, other years we make drastic changes. The GAMPs themselves are scientifically based, voluntary guidelines. That's important, they're voluntary. Farmers do not have to follow. If they want right to farm protection, they have to follow. For farm management, to minimize nuisance, okay? Within them, there are things like performance standards. They're very comprehensive, and they are evolving. Like I said, they get updated as science gets updated. Farm markets, less so, it's more filling in the gaps. but a lot of the animal science type of stuff, I mean, how we deal with a cow today is very different than we did 50 years ago, right? We've learned more through science, we know better management techniques, and so those change. They also provide legal and economic certainty for farmers, because this has been my family farm for 100 years. Grandpa farmed it, my dad farmed it, I farmed it. And all of a sudden, I get put out of business because some new housing development next door complains about the smell manure. Okay? It helps protect that farm. That's the intent of that. And it also provides some legal recompensation for farmers if they are found not to be a nuisance and they're being harassed, whether it's a township or a neighbor or a neighborhood association. They can actually claim fees and additional monies within the right to farm act if they choose. Now, most judges that we've seen usually won't award that in one case, but we had a case in Bay City area, I think Auburn area, a few years back, where a new subdivision went in, everybody bought their house in June, July, August, and it's a beautiful farmland, right, real pretty. And then what happens in the fall? Trucks are running at 2 in the morning, manure's getting sprayed, I mean, right? The reality sets in. They took the farm to court, tried to have them shut down, judge ruled in favor of the farm. This happened the second time. The third time they were back in court, the judge basically said in plain English, what the heck are we doing here? This is ridiculous, I've already told you, he's protected, and he actually awarded punitive damages to the farmer, because there's a clause at the end of the Right to Farm Act that allows for that. So we'll talk about where you don't want to cross that threshold, especially if you're a government unit, a little later when we talk about how the process plays out. But you need to be aware of that, just as a course of action with dealing with AMPs and Right to Farm. So the 8 AMPs that are in existence right now, care of farm animals, okay? So goats, chickens, bees, whatever it may be, okay? Has things in there for a government standpoint. We have an ordinance that says no more than a 4-foot fence. Anything above 4 foot is prohibited. I've got a goat. Anyone that's ever raised goats, there's certain goats, you can put up a garden fence that high and they'll keep them in. There's other goats, a 4-foot fence, they'll clear it like a deer clears it. And so the care of farm animals gap reads, remember that broad net I talked about? It reads, a fence adequate to contain a goat. What that means is if someone wants to put in a 6-foot fence, you're not going to stop it if it's a right to farm issue. Okay? So that's the things in care of farm animals. It talks about spacing for chickens, right? For feed and all that, so they're not too confined and they're not unhealthy. So it goes into that type. There's manure management and utilization. So think of cow manure, how we spread it, how we store it, collect it, all that good stuff. There's pesticide utilization and pest control, spraying for bugs, right? Easiest way to put that. Irrigation water use, how we draw water up, how we spray water. Now, I want to add, there's some other laws separate from this with groundwater withdrawal that the state has in place as well. And we'll talk about that. We don't operate in a vacuum with Right to Farm. Other laws may apply. And I'll get into some details with farm markets specifically where it can be an issue and give you some examples of that. But irrigation and water use. Nutrient utilization. So think fertilizer. Okay? You can get your hands on any of it right now for you farmers. So if you can, it's expensive. Site selection. Think of site selection as where does that factory farm go? There's 1,000 cows, 1,000 pigs, right? There's different categories. So they're not allowed, like in the middle of downtown Detroit, they may be allowed in certain areas if you meet certain criteria. If you get far enough out in the country, it's pretty much gather allowed, it's free for all, they just have to meet basic setbacks. But that's site selection. How do you choose where a new or expanding goes? Not a pre-existing. But if a pre-existing wants to expand or a new one wants to come in, they got to follow those rules. There's farm markets, that's what I chair. So think of the roadside stands, things like that, where farmers selling products from their farm to you in some way, shape, or form. And then there's actually cranberry production. I don't believe you have cranberry production on here. You do. I do. Second one I've ever come across, ever. Sheboygan County was the other one. I think it was the Sheboygan people that actually requested the GAMP be created for them. You think to yourself, you scratch your head and say, wait a minute, corn, soy, everything else is covered under like broad ones. Why cranberry? Cranberry gets their own because cranberry is the most unique farming thing if you've ever seen it. They flood fields, right? I mean, it's sometimes you do, most of the time you do. If you ever remember the old cranberry juice commercials where they're standing in the waders and they're and water. So cranberries are very unique, so they get their own, they got their own meal. It's more popular, I think, out east, isn't it, where they do that? Pretty popular.
Wisconsin.
Is that, okay, Wisconsin too. So the Commission on Agricultural and Rural Development, they're the ones responsible for these games, as I mentioned. And they're developed by the committees. And these committees are made up of experts from across the state in multiple interests. So this isn't one side. It's not just all the farmers, or it's not just all the township and city attorneys. It's a very broad coalition. And the committees include people from Michigan State University. Why us? Well, we're an ag college and we do a lot of research on animals, right? So we've got expertise there. Eagle, so that's the old DEQ, Department of Environmental Quality. So Eagle's on it because of the environmental concerns. The Michigan Department of Agriculture, MDAR, they're on it. The USDA, United States Department of Agriculture, they participate on some of these. The Department of Natural Resources participate. We have industry groups. So maybe we've got a Cherry Growers Association represented, or maybe it's an Agritourism Association, statewide group. We try to get like high-level leaders on those groups to be a part of it. Farm Bureau is heavily involved in all these groups. The grower associations as well, besides the industry groups. Michigan Townships Association, we have them involved as well, their attorney, because they represent the township interests, making sure they don't go too far. And then we have farmers. On my committee, we actually have one of the farmers that was the famous case law for right to farm back in the late 90s, early 2000s. She serves on it. And so we have a very diverse group to talk things out. And I'll talk to you about one of the conflicts that came up with how hard we push this in a little bit. But it's very robust, very healthy discussion. And so it goes very well. So I want to talk about the relationship a little more about Right to Farm Act and games. Okay? Simplest terms, the Right to Farm Act is the law. It references games. It says you have to follow games to get the law's protection. So, if you follow games, you have right to farm protection. That's what it says. Now, the process is a little more complicated than that. It's not too bad. I'll explain that as well. I'll walk you through it so that everyone understands how this would play out if there was a challenge or a complaint made. But if you have been, if MDARD says that you're following games, they give you a letter that says you're in conformance. It's called, they call it a conformance letter. Then that's when a township or a neighbor needs to really reevaluate their complaint and say, do I want to push this in? Because the way the process works out, that letter is your golden ticket. When we walk up, that's your key, that's your ticket, is that compliance letter if you're a farmer. So some of the conflicts, complaints, and legal processes, and I won't spend a lot of time on these. I just want to cover these because I think they are important and they may help trigger some questions, some Q&A later on as well. Again, I want to repeat what I said at the beginning. Right to farm is not black and white, it's very nuanced. Very nuanced. I get multiple emails a week saying 3 sentences, here's what's going on, do I have right to farm protection, or can we go after them, or whatever. And my email response back is, here's my phone number, call me. And then after half hour to an hour conversation, I can tell them with very high confidence where they stand. I have to ask questions because most people that don't understand right to farm think it is very simple, yea or nay, and I have to ask, I'll tell you, I say, like, bear with me, I'm going to ask you some really weird questions. And they're going to look at me like, huh? But once I ask the questions to get the information, I can explain to them, here's why I asked that, and this is how it directs me in terms of my guidance to you. And so we need to be aware of that. Secondly, if it's not allowed in games, if something is not addressed in games or not allowed for the games, local zoning applies. Too many townships say, farmers claim the right to farm, we can't touch them, just back right off. And that's not really helpful. Or they say, we don't need to address farm animals in our zoning ordinance because right to farm is going to preempt us anyway. It's only half right. It's half right for a legitimate bona fide operation that is a real farm business. They would be preempted. But if you don't have those rules in there, how do you handle the hobby farmers out there? You probably have a lot of those around here as well, I suspect, right? And so do you want rules to address them? The key is whoever your zoning administrator is has to understand when they walk into a situation and talk to a property owner, they need to at least do a general assessment. Is this going to be right to farm? Is this not going to be based on what they're told? If they're not sure, you pick up the phone. You call your attorney, you call someone like me, you call Farm Bureau or MTA and walk through it. Same with the farmer. If you're not sure, you pick up the phone and call. Most of these cases we can cut off before they become legal. It's when we get that call and there's already been something filed and it's going to court. We can tell them what we think is going to happen, but at that point it's usually too late. You also need to understand, right to farm doesn't exist in a vacuum. So even though right to farm is a state law, zoning is a local law, right? So if you're not familiar, I'm not going to digress on this too much. When you do planning and zoning, you have the states in America, anything that's not constitutional at a federal level is technically state business. The states have all the authority to do planning and zoning. No one in your legislature wants to come and tell Traverse City or Sutton's Bay what their zoning district should be. Because could you imagine the nightmare of this, right? You don't want to touch it with a 10-foot pole. And so what they did smartly is they gave that authority to you at a county level, at a township level, a village, city, whatever it may be, through the Planning and Enabling Act and the Zoning Enabling Act. For those of you old timers that were around doing planning and zoning prior to the mid-2000s, we used to have 3 acts, a township one, a city village one, and a county one for both planning and zoning. And those go back to the 40s. Those all got consolidated into one act in the mid-2000s. And so what they do is they're called enabling acts because they're enabling you to do the job. But when they give you that authority, they give you limits on that authority. And they give you rules to follow. But when they give that authority to you, that authority is for you to do your own local zoning and planning. But that local zoning, that zoning law, for example, is a law at a very local level. It's not a state law. So it's below a state level law. So that state level law of right to farm exempts or supersedes. If there's a conflict, it wins. However, what happens when you have right to farm law and you have other state laws at the same level? Okay, they all apply equally, unless one somehow explicitly says it preempts or supersedes another. They're all equal. So right to farm doesn't mean I'm a farmer, I can do whatever I want. You know, I can put my squash out and sell it. I can put my tomatoes out and my blueberry pie or my jam. But if I want to sell frozen beef, packaged, ground up, packaged in the freezer, I can do that. But under right to farm. But other laws also apply. Now a food law comes into play. And here's the big bummer that I give to farmers that hate to hear this. But you want to sell your kind of the stuff that isn't going to spoil real quick, right? You're not temperature controlled stuff, your crops. You want to sell those on a table under a tent, you're going to be good to do that. The minute you want to plug that freezer in and start selling that with that frozen beef, or maybe it's the raw milk, food law applies. Now that food law, if you've ever read through it or are familiar with it, it's going to treat you at a roadside stand with a table this big in a tent the same as it treats minors. You need to have bathrooms. You need to have, all the rules come into play. And so if your idea of a farm market is I'm going to put a 5,000 square foot farm market in, people are going to come inside and have fat lanes with tills, I'm going to have coolers and bathrooms, and it's going to be a big store, then you're going to go that route and you're going to follow the food law. But for most people with just that table or a small stand, you're going to say, I'm going to figure out a different way to do this. And there are different ways to do it. You're not going to sell it out there. So you need to be aware of those things. So what are some of the laws? I mentioned the food law. That's one of the biggest ones. People get into trouble. And usually, if you're a farmer, it's the food law inspector driving by. So remember, MDOT is a huge organization. And I'm not picking on them, because Michigan State were guilty of the same thing at times. When you have so many employees in different divisions, sometimes the left hand and right hand aren't communicating as well. And we realized with right to farm and food law, we needed to actually bring that together. So one of the things we did is we have a food law person on our committee, and she's actually giving a report at this year's meeting in a couple of weeks, our annual meeting, about how they're addressing some of these issues. But it keeps those lines of communication open so that we understand how each department affects the other in terms of operation. And we're also being very proactive now. If we get a call from a township from a farmer to say, oh, by the way, you need to think about these rules as well. Another one is the state building code, okay? So I don't want to go into the weeds on this. If you have questions, we can talk about it. But in essence, the state building code does exempt certain ag buildings, right, from a building permit. It's a building permit only, not a zoning permit. There's certain rules as to how that operates, based on square footage. Are you going to have electric or are you not? There's all these different rules that apply, but for the most part, there's pretty big exemptions there for ag building. However, I throw up a barn on the right. I throw up a barn on the right to farm and under the ag exemption. So not a lot of local control. I put this thing up. I don't get any permits, and I'm storing my hay, my tractor, my cows, whatever. I want to turn that into a farm market and have people walk in through that threshold and under the, through the door. The minute someone's going to step into that, you're going to have to meet the building codes, okay? It's a safety issue. And the way I think about it is I explain to someone, so I've got something plugged in for power. I really need to get a building permit for that, or electrical permit in that case, but I really need to get a permit for that. Why would you not? Because even if it's just a table like this and someone's coming up to the edge of it, and I've got power, and I've got a little extension cord from wherever, we had heavy rains for 2 days, and there's a puddle, and some kid steps in and gets electrocuted. Is that really worth the cost and time to get a permit? So you need to think about those things, but just remember that you're not necessarily exempt from them. It's going to be case-by-case basis what you're doing, and you need to be aware of that. So think about those other codes. They also exempt qualifying road stands only in the building code. Now that's a different terminology. Building code uses qualifying road stands, roadside stands. We would call them farm markets from a farming perspective within the game, okay? But those are going to be exempt as well. But again, you do need a permit if you want electric, but it's not required. If you don't want electric, you're good. It's no on plumbing as well, in terms of getting a permit. The key is these have to be seasonal, retail, agricultural types of products only, okay? I can't claim right to farm, set up my table, put up a tent, and sell the collected and shine up Petoskey stones I collected on the beach, okay? It's got to be farm products only. Anything beyond that farm product, local zoning is going to kick in on those. So we need to be aware of that. And 50% of those products, minimum 50, have to come from the farm that controls the operation, like the market, okay? So that's really important to understand too. It's got to be 50% or more. What that does is that keeps me from having 20 acres, selling whatever I'm growing in a farm market, and business is going so good, I'm going to put up a 10,000 square foot market and bring in 95% of my product from all over wherever, okay? It puts a physical limit, kind of based on the land's ability to produce, on what you can sell or how much you can sell. It gives you flexibility as a farmer to say, you know what, I'm growing 3 different types of apples. One of my apples was an early bloomer this year, got hit by frost. I'm going to have a hole for 2 weeks in my market. I need to buy apples from somewhere else to fill in that gap. You can do that, okay, for that time frame. But there are rules on how much you can do with that. Some other aspects, it's got to be under 400 square foot. If it's over that, it's got to be anchored to the ground, and the building codes are going to apply. Tents basically have the same requirements in the building code. So a tent would have similar types of requirements. Now that said, farm markets in the GAM, tents are explicitly allowed as a farm market. We allow them. It was not inconceivable when I was brought on, one of the holes I was asked to fix in the farm market GAM was you could, in theory, have 2 $10 million homes on one of your nice lakes here on the Lake Michigan, and there's an empty property in between that I own. I could literally put up a tent in the middle of that property, a tent I bought at Walmart, a little pop-up tent, and sell that as my farm market. We have since closed those gaps significantly within the GAM by some, referencing some state laws and making it a little more confined. But you need to understand, things like tents are allowed. That's important to understand. You get a lot of calls on tents, the roadside tents. So zoning permits. This is where it gets a little tricky. Can townships regulate the location of ag buildings? Anyone want to take a guess on that? It's a trick question. Technically speaking, it's unresolved. We haven't had a ruling on that. What's interesting is I believe very end of your case that just took place up here, I think the judge kind of said we need, he didn't deal with that specific issue in this case, but he references it and says, well, I don't know if he says it's for a later time or there was something in there that kind of pushed it down the road. Yes, sir.
Some of us are not from Leelanau County, so we don't really know what case it is that.
Oh, I apologize. Okay, so yes, so I'll get into the details of that case later. I've got it on my agenda here to actually talk specifically about it.
Not a quick shot of what it is.
Yes, and someone correct me if they want to. I've read this twice. Farmer had pigs. It was under the 50-unit threshold for certain setbacks. He claimed right to farm. Township said the GAMP doesn't address under 50-unit setbacks. Therefore, local zoning applies. The judge said no, because the GAMP addresses setbacks at all. Therefore, local zoning is preempted. In a nutshell. If anyone wants to correct me on that, please do. Okay. Now I'll talk a little more detail on that one too. So, with the experts, we've talked about this for years. And right now, our best guess, and we feel very confident in this, if this were to play out in a court of law, and again, we're not attorneys, but this is kind of what we think based on other court cases and what we know about the Right to Farm Act and the GAMS. We believe that a township has the right to require a permit, whether it's a use by right permit, a special use permit, conditional use, whatever it may be. The township has the right to require a permit, charge a fee. However, if what's being proposed is something that is protected by right to farm, okay, the township cannot deny the permit because the act of denial would be the point where you violate the Right to Farm Act. Because the Right to Farm Act does not allow local zoning to stop something that's allowed under the Right to Farm Act, okay? So you would have the ability, and there's a good reason why townships want permits, or county, or whatever it may be. You need it for assessing purposes. We need to know when the building's going in because we have to assess the land appropriately. We need to know if it's going to create a traffic hazard, or it's going to create some type of issue visually, or whatever it may be. Now, setbacks are a whole other issue that we'll talk about because of the case, the nuance of that. But there are some things where local setbacks could be applied. Okay, if they're not addressed in the GAMP specific, there are certain areas where setbacks could be applied. And don't quote me on this, but I think, for example, fencing. I think, you know, GAMP says you can have fencing, but I don't think there's anywhere in any of the GAMPs that says it can be on the property line necessarily, at least within the GAMPs. And so, you need to be aware of that is it's the act of denial of something that is allowed under the right to farm. That's where a government crosses the legal threshold, is what we believe. And until that's adjudicated in court, we'll see where it goes. But that's, I feel very confident in that. If you call me on a particular case, I will tell you that, based on our best educated knowledge and guess of the situation. So, complaints. I want to talk real quickly about the complaint process here. We have a few minutes left to talk about this. So complaints must be made, like a complaint can come into a township, right? A neighbor says, you know what, that smells, I don't like it. The township can make a complaint themselves. Someone can make a complaint to MDR, okay? If it's an easy enough case to work through, a lot of them we can. You call someone like me, we can work you through it and say, here's what we think. You probably can figure it out without having to go to MDR. If it's going to go legal, okay, if we're going to issue a ticket, there's several different ways this can play out. From a township standpoint, if you don't think it's a right to farm issue, and you think your zoning applies, you treat it as a zoning violation. Let the farmer claim right to farm and let them defend it in court. Work with your attorney because you want to make sure you're on solid ground with this one. But if you think you're in the right, you stand with that defense. Let the farmer prove in court that it's right to farm. Okay, most of the time we can tell you what that situation is. If you're a farmer, you can claim right to farm, but you may have to go to court. You have two options. The first is you can preemptively ask MDR, the right to farm division, for an inspection, for compliance. If you as a farmer ask for it, the only warning I give to farmers is if you do that preemptively, they are required by law to do a full inspection of your whole farm, not just the issue at hand. So if the issue is simply a setback or 3 cows and I've got 1,000 pigs, they're going to do the whole operation. Or you can wait if it's requested by the township or by the courts, the MDR will come out and do an inspection, only do it based on what the complaint is, okay? What's gonna happen then is MDR is gonna provide a letter of either you're in compliance with GAMS or you're not in compliance with GAMS. Understand what I just said with GAMS. It doesn't say you have a right to farm protection. It says you are in compliance with GAMS or you're not in compliance. If you're in compliance, you're good to go pretty much. I mean, you could still have it in court, but you've got the protection you need. If you're not in compliance, usually MDR will give you a list of here's what you need to do to get in compliance. And if you get in compliance, they can come back out and say, okay, you're in compliance, you're good. Okay? So that's how that process works. Now, if you as a township are going to pursue this, or a county or whoever, maybe a city, if you're going to pursue the issue further, you get into court. You've got to be careful of that compliance letter. And this is where your attorney, if you're not certain of this is where they give you a call and say, how does this work out? By law, two things by law. The only person or group, the only authority to determine compliance or not compliance with GAMS is Michigan MDR, the Right to Farm Division, okay? They're the only ones. The only person allowed to grant right to farm protection is a judge in the courtroom. How does the judge make the determination of right to farm protection? I don't want to oversimplify it for you, but basically, they have to determine what we talked about at the beginning. Are they a bona fide business? And are they in compliance with GAMS? The business is easy. It's either a yay or a nay based on sales or whatever, and that's usually pretty easy to figure out. The GAMS compliance is simple. Letter of compliance from MDR. If that letter exists, I'm only aware of one case where a judge overturned that because they said MDR didn't do the inspection properly. They misinterpreted a very specific rule. And, but in most cases, the judge is going to look at that in plain English, look at the township and say, why are we here? This compliance letter been granted, why are we here? So you need to be aware of that if you're starting to get in that legal realm, and hopefully your attorney is educated in municipal law and understands right to farm. I'm finding more farmers nowadays, more attorneys nowadays are getting better educated on right to farm, but there's still a big gap there with some attorneys. So it's very important, and that's where you talk to experts if you need it. In fact, a lot of times when I talk to a township, the supervisor of water and property says, okay, the next step is I'm setting up an appointment, you're talking to our attorney for us. You need to explain it to him or her because it's, there's a lot to this, right? And we don't want to step it if there's a problem. So I think that kind of covers it. If the judge determines that they have right to farm protection, they're no longer a nuisance, there's no grounds for the lawsuit, case dismissed. Now that said, it can be much more nuanced. It could be they've been given right to farm protection on 3 of the 5 accusations. The other 2, they could still lose. And it's not uncommon to see splits based on kind of topic by topic. It's not always an all or nothing. So that's important to know. Some common recent conflicts I want to talk about. So agritourism is one of the big things right now, and I'm sure that's huge up here. It's things like wedding barns. If I have a winery and over the summer I've got a group of school teachers coming up from Grand Rapids, can I have a little B&B or some bedrooms under right to farm to house them? Things like that. Another big one is food processing. That's a huge one we're going to talk about as well. These are not considered marketing activities, quote unquote marketing, under the GAM. Okay? So they are things that are controlled by local zoning. No ifs, ands, or buts. This does not include things like farm to table. So if a farmer wants to have 10, 20 farm to table events to sell their product, and you come in and have the wine, or you have something growing on the farm, and you buy tickets or whatever, and it's a limited event. Those are allowed. Okay? The key is, and this is something I had to fix when I came in on this committee and worked with our committee on, is we use the word incidental multiple times. The activity, if it's going to fall under marketing, it needs to be incidental to the farm operation. So, I'm going to use that farm to table. I've got a farm, and I'm going to throw just a couple weird numbers up. $500,000 in annual revenue sales from that farm. I do 10 farm to tables in the summer. I make 20, 30,000, I don't know, whatever. That's incidental, not a big deal. All of a sudden, instead of a farm to table, I have a restaurant operating 10 in the morning until 10 at night, 360 days out of the year, and I still have 500,000 in revenue sales for my farm, but my restaurant has sales of 2.5 million. That's not incidental. Okay? That just became a prime commercial business. And so we put language in there legally to limit how big those activities could get so it didn't get out of proportion. Now, in fairness, so there are groups out there that lobby for agribusiness and agritourism. The wedding barns is a big one. And there's a lot of issues. Grand Rapids is a good example. The surrounding countryside of Grand Rapids, some townships allow them, some don't. There's a bunch of legal fights. And it's a township by township zoning issue. And so the association at a statewide level said, we can't fight this township by township, right? There's 83 counties. How many townships are there? Somebody can math it. It's a couple thousand. And so they lobbied heavy through the legislature to try to get some type of law passed to allow for agritourism, agribusiness. They weren't very successful, and a lot of it got worse in recent years because there's so much infighting at the state level between the parties now, can't get anything done. And I mean, that's way on the back burner. It's probably not going to happen anytime soon. So they came to us, and they wanted us to explicitly include in the definition of marketing things like wedding barns. We had to take a serious step back and have very hard discussions about this. Because for us to do that, whether we wanted to or not, I'm not going to argue yes, no, or different. If we wanted to change that definition to include things like rooms off the back of your winery to sleep in, or the wedding barn, or even food processing, right? So I want to actually, I can grow the grape, I can sell the wine, but if I want to make the wine, I can't do that on site unless I have local zoning permission. For us to include those types of activities would artificially expand the intent of the right to farm law. By doing so, we would have overstepped our bounds, and we would have risked opening up right to farm and having it gutted by particularly Southeast Michigan, which aren't a big fan of the right to farm law to begin with. We could not in good conscience touch that. The state law says, here's what this is for. It's about production and selling of your products, nothing about processing. So we had to really back off those things, including like the event barns and all the rest. So we couldn't do that. And so I want to explain the difference, because we're going to talk about this in planning and zoning in just a second. Production versus processing. Production is growing. Plant the ground, grow it, harvest it, whatever it is. Okay? Processing is making that product into something else. So growing a blueberry is allowed under right to farm. Selling that blueberry pie is allowed. Growing your grapes for wine, selling the wine is allowed. Or selling the blueberries just in a basket is allowed. You don't even have to process it. But making that, you can sell the blueberry pie for the jam, but you cannot make that pie under right to farm. You don't get protection to open up a bakery and start making that pie, making that jam, or distilling that liquor or that wine or whatever you're going to make. You don't have a right under right to farm to do that. Okay? Right to farm simply doesn't extend those protections to farmers. So that is a local zoning issue. And it sounds kind of dumb, right? It's like we've got A and a C, but no B. And there's kind of a reason for that, because where I live, we have Gerber baby foods, food processing, right? It's where baby food started. And I don't know, 900 employees or something like that. It's a massive operation the size of a small town. How do we regulate for that? And so we're going to talk about some techniques when we get into the planning and zoning part of how you can address that at a local level if you want to encourage the value added to farming. The recent case, and I'll talk about that a little bit just from what we saw. So Leelanau Township here, there was a pig issue, and the GAMs are very specific about animals, okay? They talk about 50 animal units. One animal unit, it's really weird, I know, I gotta get that look like, huh? I saw that, what is an animal unit? An animal unit is 1,000 pounds, basically the average weight of a beef cow, okay? So one hog does not equal one animal unit. 3 hogs equal one animal unit. If you do the math, right? I know. One dairy cow equals like it's less than a 1 unit, because they tend to range, what, 12 to 1,400 pounds. So they actually count for a little less. So do the math on a really light chicken. It takes a lot of chickens to equal 50. 50 is the threshold in the GAMS, where they kind of separate the scale of operations. So above 50 is where you get into a lot of regulation, because that's what you get into what we call CAFOs, or like the factory farms. Okay, see a lot of heads now. So that's important to understand that difference. In your case, you had a situation where a farmer had pigs, but under the 50 animal units. The GAMP specifically addresses setbacks for over 50 animal units. It is silent on anything under 50. So the township and the township attorney went forward with the understanding, because remember I said before, if it's not in the GAMP, if it's not addressed in the GAMP, then local zoning applies, right? And if it is addressed in the GAMP, local zoning is preempted. This is part of a conversation we have had for years internally, privately, waiting for a case like this to actually occur. Our internal gut was the same as what the judge wanted. What your judge basically said in plain English was, even though the GAMP didn't address setbacks for under 50 animal units, it did address setbacks for over 50 and chose to be silent on the under 50. But because the way the right to farm law is written, because the GAMP addressed setbacks at all, then local zoning is preempted, because it did address it. And that was the one nuance. We knew if it was not talked about at all, local zoning applied. If it was talked about and addressed, your local zoning was preempted, it couldn't supersede that. But where we always had questions for many years is, what if it addresses it partially? And so, what I can say we did with the farm market GAMP was we addressed this issue. I mentioned this a little earlier. We addressed this head on several years ago, because our gut was telling us what your attorney or your judge said, is that if it's addressed at all, it's going to be preempted. And so we did that with signs. We knew if we allowed signs, but only addressed having one, and nothing about bulk or all that, a judge could rule in that paper and say, well, wait a minute, because they address signs, you can't tell a farmer what that sign can be, how big it can be, how lit up it can be, things like that. We also did it with, so we have something similar to yours, that 50 animal unit within the farm market. If you're over a certain square footage, 120 square feet, that seems very arbitrary, but it's not. It's actually the size of an accessory building in the building code for commercial buildings that requires a permit. So anything over 120 square feet, you must maintain a setback of 165 feet from the nearest non-farm residence, not including your own, of course, if it's right off your house. 165 feet, by the way, seems very arbitrary. It's not. It's based on the Land Division Act and the meets mound system. There's a reason acreage is like 160, 80, 40, 20, 10. It has to be the way the Land Division Act kind of works historically. 165 is kind of like the middle ground of when you follow through a whole page of mathematics. You get down to 165 is like the halfway point. So that's how that number is chosen. It's rooted in state law. So it's not arbitrary. We can just make it up, a random 100 foot or whatever. But the idea here is that we have that same situation with the farm market that you went through with the pigs. Now, it was a different GAMP, but if someone wants to put in 120 or more square foot, they got to be 165 foot back. We don't address setbacks at all for anything under 120 square feet. And that's intentional, because anything under 120 tends to be very limited in its impact, right? 120 square feet, you're not going to have 50 people walking in and out of the door, right? It's too small. It's anything that size is going to be a tent with a couple tables. It might be something as small as a refrigerator next to a garage, a lady selling eggs. That was actually a case law. And so the interpretation of would also apply, I would argue, to our situation with farm markets, where if it's under 120, even though we don't address like setbacks at all, the local setback wouldn't apply in that case, because we address setbacks at a larger scale. So I think it was a rational decision. I understood why the attorney wanted to go for that. I think we felt fairly confident, not 100%, but fairly confident a judge would rule in that direction if it ever came to court, which they did. But we also recognize the potential for a judge to kind of say, well, no, that's not addressed, I'm gonna go by that letter of the law, and we're just gonna allow local zoning to stand. The catch here is this is not being appealed from, correct, right? Is the township not appealing this? Okay. So, this stands for your local area. Other judges could use it as guidance. I think the judge did an excellent job explaining it and walking everyone through it in his decision. But if it were to go to appellate court or go to the state Supreme Court, we'd have more clarity for the rest of the state. But as it stands now, I mean, this is good guidance, I think. We have had some cases, but I've actually had my testimony at the state Supreme Court on a right to farm case. It happens, and we don't want to encourage someone to challenge it because basically, you know, if you're from that township, you're the guinea pig, you're paying the money. You know, the winners of this are the attorneys, right? They make money. So we try to keep it out of the courts if possible, but if it does go, so we try to limit it. At the end of the day, if you're not sure, always consult your attorney. You have a lot of good resources. Use us first. I don't charge for my time. You know, you pick up the phone and you call, drop me an email. Farm Bureau will do that. MTA, if you're a township, they have actually a free call-in legal advice day. I don't know if it's Tuesdays, Wednesdays, or Thursdays. It's one of the days of the week. You can call in, you talk to Catherine, and get advice. But if it comes to the point where there's going to be some action or you need more clarity, that's when you talk to your attorney. So real quickly here, planning and zoning for successful agriculture. My job is not to promote ag or fight against it here, but my understanding is, you know, besides right to farm, what else can our communities do to help encourage, promote, protect agriculture in our community? And so, real quickly, overview of agriculture and why it matters. I was involved in several studies, statewide agriculture related to the Great Lakes Compact and water in the Great Lakes. The short of it is this: agriculture is the second largest industry in Michigan financially. Depending on how you do the math, if you look at the broader impacts of agriculture, you know, secondary and tertiary effects like transportation, all that, it actually could be number one. Most economists agree it's number two. West Michigan, so we're part of this whole state. Well, I live up to you guys. West Michigan is the second most diverse agricultural region in the country. Most people don't know that. Second most diverse. Anyone want, this is your gold star moment. Anyone want to guess number one?
Go for it.
Central Valley of California. I'll give you half a star, yeah. No, very good, very good. What, the difference is this. What do they have? They have a Mediterranean climate. They can grow citrus. They can grow almonds, things that we can't grow up here. Okay? We have our own microclimate along West Michigan. That's why West Michigan is the way it is, because of the Great Lakes, because of Lake Michigan. However, what is California the problem with? If you're a farmer, you should be aware of this.
Water.
Their water is all run off from the mountains. There are areas where farmers are 90% or more cut off from that water because of the smelt, with about a 5-inch fish to frighten you. Okay? Michigan sits in the middle of 1/5 of the world's surface freshwater. 1/5. We are the Middle East of the 21st century again. Water is becoming a big issue. The Great Lakes Compact, when Granholm was our governor, there was a reason. It didn't matter if you're Republican, Democrat, American, or Canadian. We were all on the same page on this water thing, right? If you look at Canadian provinces and states that make up the Great Lakes, that touch a Great Lake, if we became our own country, and the USA was left, we'd be one of the most economically powerful countries in the world as a region. There was push from parts of the southwest of our country of trucking out water or eventually building a pipeline out of the Great Lakes. So because of the US Constitution and Interstate Commerce Clause, we basically had to prove that 1 inch of water, every layer of water, is worth more to us than to them. And so that's where a lot of that data came out of. But it's important to understand that. We sit in a prime ag area globally. Very, very important to understand. We also need to understand industry changes, right? You know, farming today is not the same as it was 20 years ago as it was 100 years ago. Very much now, farms go, at least in the central part of the state where it's row crops, go large or go home. You got specialty crops. So up here you got a lot of your specialty because of your climate, your microclimate. And they capitalize on that with tourism because of the area as well, and wines and things like that. Where I live, there's a lot of people that do goats. And they might have 7, 8, 10 acres. And they do goats. Why do they do goats? Because there's a big Middle Eastern population in Grand Rapids and they supply the restaurants down there in Golden. There's the same thing around Detroit, very specialized. Organic is another one, right? You do organics, you can do it small scale or greenhouses, things like that. So you always have to be aware of the changes. We also need to understand there's some areas that we don't want to protect. If it's a suburb of Grand Rapids and there's 2 miles around you that's nothing but subdivision, you may not want to do anything special to protect those last couple of fields. If you have an area where it makes a lot of sense, it's part of your economy thrive, I would argue where you are. This area up here, Leelanau, Parcel Township, there's a lot of good that provides, beyond just the farming, which is lucrative as well. You've got the wineries, which bring in tourists. And those tourists stay in hotels, they stay in the area, they spend money in shops. So there's an advantage to that. And if you see that as valuable to your community, then helping to protect those types of assets makes sense. We have the same rival, because we have all the muck fields, the vegetable growth, because of Gerber baby foods. And so agriculture is huge where we are. We need to protect that in certain areas. And then maybe put housing, we'll talk about some of the techniques in zoning, but how do we do this though? How do we do it from a planning perspective first and then the zoning? From a planning perspective, you're always starting with your master plan. So for those of you that serve on a township or a county, you understand what we're talking about. If you're a farmer, maybe you've never dealt with it. A master plan is a policy document. It's not a legal document, but it's a policy. And that policy is like that 20,000-foot vision of your community that your laws, your zoning is going to be based on. And so everyone I ever read is very similar. We have this beautiful rural character, rolling hills, beautiful farms, wonderful forests, beautiful creeks and lakes and wildlife and blah, 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 blah. Great rural character. That's a great vision statement. Your plan should have that. Point out at a very high level what makes us special. What do we appreciate here? What is it that we want to protect and preserve? If we want to beat the next Traverse City up here, go for it. That's your plan. That's what you decide locally. But if you want to protect that, you need to address it and call it out. But doing that in and of itself is not enough. You have to go a little deeper into the weeds of your plan. Your plan needs to analyze the situation and develop goals and strategies that help you get to that vision. Okay? And so I'm not going to delve too deep. I mean, this is like a 3-hour training we do just to scratch the surface. But in general, from farmland's perspective, it's not enough to just say, here's our existing farms, this is where the farms operate, that's what we got to protect. If you do that, you will fail. That's part of the process. You need to be more comprehensive. You need to look at your soil types. Where's our good prime farmland? Where's our marginal farmland? You need to look at lot sizes. Where is the infrastructure of the lots intact for large farming operations? Where is it, maybe you're on the edge of Grand Rapids, I'll pick on that because it's had a lot of urban growth, where everything's getting cut up so much, we're cutting off ag, choking it out, it's dying, it's slow death, right on the edges of town. Maybe that's where we not direct it from. I think your county abuts the city, does it not? When you're going, okay, so there's a lot of development on that road. That area might not be prime to protect because there's a lot of commercial development, but maybe quarter mile in it might be. So those are discussions you have and identify. You need to look at the operation scales of your farms. Are they all these small niche markets? Are they big, vast? Like you go to Gratiot County in the middle of the state, north of Lansing, I mean, you can see for miles. It's flat land and it is farms. So it's a different type of operation than maybe your cherry trees or your apple trees or whatever it may be, or your grapes, your vineyards. So take a look at that. Or if you're doing a lot of organics, if you go into New Mexico, up in the mountains, there are a lot of greenhouses. Some of them, a handful of greenhouses, can make $200,000 a year doing organics because they can grow 12 months of the year there. And there's a high premium for organics. So what is it? You got to take a look and see what your community is doing. You need to look at, what are the types of farms like? So what are they growing? What are the industries around there? I'm sure you've got a really strong cherry industry that's pretty organized. I don't know if the vineyards are or not, but what are those industries? Look at your land fragmentation. It's easy to do if you have county GIS.
Yes.
Okay, you pull up the parcel layers. Maybe your county, I don't know, 3 guys on the bus, maybe it's something you can do. You take a county map of all the parcels and you make categories. Over 100 acres, yellow, green, and you kind of break it down by size, maybe 80 to 100 or 40 to 100 or whatever, and then 40 to 20, 20 to 10, and then under 10 or under 5. And then it gives you a good view of your community. Where is the development denser? Where is it happening? Where is it not happening? Where are the large tracts of lands that maybe we want to protect? Look at things outside of zoning. are there programs that might make sense? It may or may not for you. I think over across the water there, they had a PDR program, Purchase Development Rights program. They had one in Kent County. Some have worked, some haven't. Is that something you want to consider? That's a local discussion. I'm not going to tell you one way or the other, but there are other techniques. Things like conservation design. We'll talk about that under a zoning technique in a minute, but it protects large tracts and still allows the farmer to develop some of it, make some money, have some housing come in, but still a functional farm. Solar and wind, these are real controversial issues. They would not exist if they weren't subsidized. Wind was subsidized for years, solar is being subsidized now through tax incentives. You need to make a decision. Do we want this in our community or not? There's objective and subjective truths. Objective truth is 2 + 2 = 4. You can argue, sir, all day long it's 5. You can argue, I'll argue it's 3. You tell us it's 4. There's an actual truth. It's 4, right? Subjective truth is you like blue, you like green. You're going to have a fist fight over the best color in town after this meeting. You're never going to convince each other because it's a subjective truth, right? So you have some of that going on with things like wind and solar. Some people say, hey, they're a great thing, they add to the economy, because farmers can really offset their costs, especially in years where they lose some crops. They can make a lot of money on leases for wind and solar. But at the same time, people might not, some people might love looking at them and think they're great. They're a symbol of, clean energy. Other people are going to look at them and say, I'm getting a migraine every night at 6 o'clock, flick to the west, because I'm eating dinner at the kitchen table. And those are, some of those are value statements, subjective type of things. And so those are conversations you need to have as a community. Do we want those going? Because some farmers that have solar and wind, they make a lot of money. I mean, there was a gentleman over in Thumb area, he's one of the first solar farms to go in. He was getting $64,000 a year for his leases. He was one of the first in the state to do it. This is back in the late 90s, early 2000s, sometime in there. $64,000 a year. Think about that. I have an entire crop failure. I'm not going to go over, right? I've got some money there coming in. And so those are conversations, if you haven't had, as a community, you should have, and include the farmers in and see what they want. I always say include the farmers in everything, because they're a big part of this, right? They're the ones on the land. And farmers aren't always on the same page. I work with the community. One farmer wanted to be able to sell off his land because his kids weren't sticking around. It was his retirement. Another farmer wanted to protect it because his kids were taking over the farm. They got along great. They were friends. They had different views. And so what is it that you want in the community? You need to talk about that in your plan. You need to think about odds and ends that most people don't think about. Your transportation infrastructure, right? Farmers need heavy trucks. They need the ability to get those trucks in and out of an area. So what's your transportation infrastructure looking at? What about food processing facilities? We talked about right to farm. Doesn't allow food processing. If that's a value added that farmers want to do, I'm not arguing for or against, but let's say a winery says, geez, if you made it easier for us to make our own wine, or maybe it's our grape jelly or whatever, do we want to allow that? You could have a zoning ordinance similar to the GAM that says we will allow on-site processing of on-site products as long as that processing is, for argument's sake, 50% or more on-site. Right. You could do that yourself. Or you could even make it 100%. Some communities want to do 100. It's up to you, but that would control that little operation from becoming a monster operation unless they bought up enough land to expand it and have enough profit coming in. So you can do things like that if you think it's valuable. You could do, and wedding bars is a real controversial issue because it's not usually an all or nothing. It has to be very nuanced as well. It might make sense out in the middle where it's half a mile away from any housing, but if it's from here to the parking lot away from a neighbor's house, having rock music at 2 in the morning at a wedding is probably not a good idea. And so, but can we make provisions for something like that? Does it make sense to allow that as value added? Does it make sense to allow for other types of tourism or agritourism operations? You need to talk through those, see what the demand or the need is from the farming side, and then say, rather than make it an all or nothing, what can we do to allow it, but at a reasonable scale that benefits the farmer, but still protects the neighbors, okay? And that's not always easy to do. It takes a lot of conversation, a lot of work, but there's nothing I've seen in this that can't be done if the effort's put into that. These considerations will help you develop a comprehensive strategy to help sustain and grow agriculture within your plan. However, this is not an all or nothing. farmers versus housing or versus residents or whatever it may be. Both can coexist and thrive if you do it right. The advantage you have up here, your communities in this area, I know this area was mentioned earlier, so I grew up in Saginaw, but we had a cottage in Wallen Lake up by Charlevoix, Petoskey, that area. And so we spent a lot of years in Northwest Michigan. You tend to be way ahead of the curve up here on these types of issues than downstate. I mean, there are communities I work with where, how do we do emotion? How do we do, real basic stuff? It's handled. And you've got staff in a lot of your communities to do this. You've got a lot of talent in your communities that serve on your boards. I think you have the ability to not only do this, but even lead the state. If you want to address this issue and really look into how do we help ag thrive and not cut off housing and find balance. It's a delicate dance, but it can be done. You must be intentional and deliberate in your process. Okay? You need to be flexible. Things change. Farming changes. I mentioned that earlier. We always need to be looking at, okay, we did this, let's evaluate it in 3 years, 5 years. Do we need to change it? Are there conditions changing that make us change what we're doing or tweak it a little bit? And then, a good example when I talk about the all or nothing is the conservation design, is a zoning thing, right? We talked about that. Why not look when you do your analysis, when we talk about transportation, your roads? A primary road is a great place to put denser housing development or feed denser housing development onto. Your primary roads tend to be where your sewer and water runs you, if you have it out there. If you don't have it, county can plug your ears, but are you the commissioner? So you can plug your ears, but, well, it's your road commission, so you don't have to worry about it. But who pays for county primaries? County does, right? Let them pay to maintain a high quality road that you can feed your heavy traffic on. If you've got a dirt road or an unimproved township road, maybe that's not where you want to put all your housing down, necessarily. I mean, those are decisions you can consider. And if that's the case, maybe that's a good spot for more agricultural development, okay? So really look at the nuances of your community. I always encourage housing development to be built off of your primary roads, whether it's a county primary or it's a township road that's well maintained. But then also sewer and water, your infrastructure, right? People building nice houses will want those services for the most part. And then allow the non-developed areas to be a little bigger lots, more rural communities. So the key in all of this, and this is critical to understand, you can put everything that you ever wanted in that plan, okay? But if your zoning ordinances do not reflect what the plan calls for, you will not achieve the vision of that plan, okay? So from a zoning perspective, in terms of agriculture, I mentioned earlier, right to farm only goes so far. So consider filling those gaps. We talked about ag processing. We talked about scaling it so it doesn't become a monstrosity. We talked about agritourism. We talked about things like barns, bed and breakfast. Again, like a bed and breakfast. Wyoming wants to put in some rooms. It doesn't have to become the next Hilton or Holiday Inn. You could limit it. You could say, well, you can have up to this many rooms, this scale, whatever it may be. You have that ability to control that through your local zone. So think about that. Even on-site things like on-site stores and restaurants that are maybe stores might be selling more than just the produce. Always remember scale, keep it appropriate where it belongs, and rules to preserve lot sizes. So you're in a farming area, you want to preserve those farms, the large lots, and keep that rural character. So when you're driving out Peninsula Township over there next door to you, you're looking over and you've got these huge fields. We don't want to become all subdivisions. Well, how do we protect that? There's different techniques. I'm not going to delve deep into them. I'm just going to mention them. You could use techniques like quarter zone. You could use large minimum lot sizes. It doesn't have to be 2 acres everywhere in the whole township. It could be maybe a half an acre here, or even less, quarter acre if you've got sewer and water, and maybe the farm areas are 40 acres or 20 acres, whatever you want to do. You could use more advanced techniques where you say, for every, and this is kind of a middle ground, the farmer can sell off some, make some money, but not completely close off the farm. Anything 20 acres or more, we allow a maximum of 2 splits. And those splits can be no bigger than 2 acres each or 4 acres total. So we still maintain the integrity of the farm area with a house or 2 on it. You could do something like that. Those are techniques. The conservation design. Conservation design lets you put neighborhoods. So traditional neighborhoods in flat, where we come from, where it's real flat, around my Grand Rapids, you take 40 acres and a house goes on every single little inch of that land, right? There's a road going through it, you've driven through them, they're cookie cutter. What conservation design does is it encourages the development more densely. And there's actually bonuses involved where a developer, instead of getting 20 houses, can get 22 or 23. And so there's a bonus to them financially. And then the remainder chunk of land, a certain percentage, I think it's 40% of state law, and that has to remain in perpetuity preserved. So if it's a wooded wetland area, maybe it's a nature area where you can just walk, hike, or it's preserved. If it's a farm area, it can still be farmed. So a farmer can cash in on the development and still farm. So if I've got 40 acres and 12 acres of it are woods that I can't farm, I could use conservation design, put all the houses on those 12 and still keep farming the other, what is it, 20 acres, right? So those are techniques you could use. Those are things you want to ask your planner about, or you have to talk to you differently about, because they're pretty complex, but they can be done, and they work well when they're done right. So they do require a little extra effort, professional planning, maybe even some legal assistance, but it really is worth it. Do you use any of those techniques up here, just out of curiosity? I thought I saw some of that when I was driving around. It looked like there was a little bit of that someplace.
Open space and cluster housing.
Yeah, I know like Harbor Springs area does that quite a bit. Yeah, okay, good. So with that, I'm gonna stop. Not pretty long, but I can take Q&A as long as you have them. I might repeat your question just so it gets recorded for people at home listening. And then I can also stick around if there's something you don't want to talk about in front of the whole group, you just want to ask me or whatever. I can stick around as long as you need me until they kick us out and lock the doors. So. And we did have actually, before we began spoken it up, there were 3 questions that came in.
Yes, you want me to go ahead with those now?
Please do.
Okay. Can a
One at a time.
Yeah. Can a local government limit a farm market as defined by GAMPS to the agricultural zoning district?
If it is protected by GAMPS, if it falls under GAMPS protection, therefore right to farm, if it's following GAMPS, it's not right to farm protection, they cannot touch it. No, it's pretty much a free-for-all. The only controls that are built into the GAMPS in terms of location of a farm market are if the area is platted, and I'm very specific about that term. Parcels are Land Division Act, big parcels, right? You go to your local zoning administrator, assessor, whoever does the splits, you get 40 acres split into 20. That's a parcel. A plat is a process in the Land Division Act where you go through a legal process. It takes 18 months to 2 years. It's got to go through the courts, get approved by the state. And those are the subdivisions we grew up in. If you grew up in a subdivision, most of those are platted. Cities are almost completely platted, right? There's room for streets. There's room for, okay. The other exception to that is if it was done under the Site Condominium Act in the 80s, which is basically just like a plat, but it's a quicker process. It doesn't take 2 years, it takes a few months. So if you're on land that is platted, local zoning applies. If you are a farm market that does not follow GAMPS, zoning applies. If you are not on platted land and the farm market follows GAMPS, the township has no ability to designate what zones it can or cannot go in. So
Okay.
that's why I asked you this one.
Okay, second question. I have 2 more. Can a local government require a farm market, as defined by GAMPS, to be located on a minimum parcel size, such as a 10-acre parcel size?
Everything I just said applies to that too. The answer is no unless. So the township cannot, for something that is following GAMPS, protected the right to farm, and not on platted land or subdivided land, they can't control the size. They can't say you can only do this with 4 acres or 10 acres. If it's not something right to farm, it's a hobby farm, right? It's my pet goats, it's my pet horses, whatever, not a business. Then you have every right to say, okay, anything under this acreage, none, across the whole township, none if you want to. Or, 1 horse per 1 acre and 2 for every 2 acres or whatever it may be. You could do that. But the short answer is if it's following GAMPS and it's not on subdivided land, then the answer is no.
Okay.
They have no control over it.
I'm going to add a follow-up question on
Yeah.
that one first.
Go ahead.
So can a township then require the the owner of the farm market to produce a certain percentage on that farm or on contiguous lands and so forth?
If it's not following GAMS, they could put rules like that in like a conditional use permit. They could say, look, you want to run a legitimate business, but you don't want to follow GAMS. We're going to have rules that say this percentage. If they're following GAMS, you don't have that ability because the GAMS itself defines 50% or more has to either sales or product have to come from that site. So you don't have the ability, let's say as the township, to say, okay, the GAMS say that, so we know you can be there, but you can only sell cherries from the neighboring 3 counties. You can't get them from Washington State or from Poland or Turkey. Can't do that. As long as they meet the requirement in GAMS, they're good to go. You can't regulate it. If they're not following GAMS or there's some other type of, maybe they come to you and say, look, we want to do farm products, but we also want to sell 50 other things, and we're going to be a retail store or a commercial store. Then you could, in theory, do that to limit it.
Okay.
So, yeah.
Okay, and last question. Can a local government require that a special land use permit be obtained to operate a farm market?
Yes, that goes back to the point I made earlier, where you have every right as a government to require a permit. Where we think you cross the line, our educated guess, is if you deny a right to farm protected or someone following GAMS, if you deny them that right, that's where you get into trouble. Like the farm market, for example, we straight out say, here's what a farm market is, and you're allowed to do it. That's all we say. And so the authority's been given by the state to do it. You can't stop it if they're following the rules, but you can require a permit. Yeah. That's it.
That was it for me. Yep.
Questions, anyone? Yes, sir.
I got a quick one. I know you said does not allow food processing. Look, do you really mean does not cover that? I mean, somebody can food process on this thing.
Let me clarify the wording. Rather than say does not allow, the Right to Farm Act through the GAMS does not preempt local zoning for food processing.
It doesn't protect food.
Exactly, it doesn't give you the protection. If you want to do that, you need to go to local zoning. Hopefully they have something for you. If they don't, there needs to be a conversation with local law. Maybe the township doesn't want it at all, and then you're out of luck.
Right.
That's where you're running for the board in the next election.
Does not protect.
Yeah. No, it doesn't provide that type of protection. Okay. That was that. We give you A, we give you C, we don't give you B. Right. Okay. Yeah. Question? Yes.
Can I ask one that takes just a little bit of background? I can do it quickly.
Go right ahead.
And it applies to everywhere around here, 30 miles around.
Okay.
So we live in a high amenity township. We've got a lot of successful farmers. A lot of properties have been held by owners for generations. We've got some pretty intelligent people, grew up in our community, went off to San Jose, came back as millionaires, bought some of these high amenity view areas. One built a monumental home. But he was a local person, we knew him, and everybody, this is just what you do. And so he decided that he was going to put in a vineyard, and he went through all the proper steps. Got his grapes growing, got his fermentation stuff all in place. He got to where he could grow and make wine, but of course he didn't have any grapes. Our local ordinance about ag-related activities say some percentage of your stuff has to come off the ground. Well, he wasn't getting that. He came to us and he asked if we would waive that part so that he could bring in some juice from other places so he could get going, and that made sense. And it all made sense, and it fit perfectly with our master plan that talks about preserving agriculture. We have an ag zone, big ag zone. But then, for reasons out of this person's control, there ends up being a court involvement where he suddenly has to come up with some money. And so what we find on the market being offered as an event venue is his beautiful home overlooking our high amenity, surrounded by people who, over the years, have told us they don't necessarily want to hear about music.
You turn the house into an event.
Yeah. And our issue at this point, we've told the realtor, you got to stop selling, you got to stop building it that way, because we're going to tell you right now, it's not allowed. It's not allowed. And of course, that's not very satisfying on their end. And, if that was the only case, but that's very often, local people who've been there and lived here, we try to do everything we can to help the people that And then there's a successor to that proposition with a whole lot of money and a whole lot of different plans. And everybody from Peninsula Township to Benzie, on the quick path to Benzonia. I mean, you don't have to go very far to find these issues that end up costing the taxpayers a whole lot of money. And, you know, when you guys start deciding what in the world it is that really is a legitimate agricultural interest, you know, my family's been on my farm for almost 150 years. And we've done everything we can to optimize the return on what we've done. And we certainly can't begrudge somebody trying to make sure that they can do the same. But it's a little bit different when you're talking about an investor group from someplace else who, well, this is a pretty nice vineyard. It's a pretty nice view in both directions. This is a wonderful place for us to have a daily, big-time revenue-producing operation going on.
So in that case, it's a very nuanced case. I heard 3 different distinct aspects to it when I'm listening to it from the legal perspective here. And again, I'm not your lawyer, but, so the first is assuming, and let's for argument's sake, they're following the where GAMS apply. The growing of the grapes is not going to be an issue, okay? The fermenting of them is going to be completely a local zoning related issue. It's something you decide local as to how much and what scale. And in your case, I'm assuming, and I could be wrong, but some type of special use permit was granted for that.
Yeah.
Okay, so in this case, if they extend the boundaries of that special use permit, there would be recourse for the township to go after. If the township basically granted a blanket, go ahead and do it, you might have trouble fighting that because he's got a permit saying he can do it. There's nothing in there about, we actually lost in Leelanau County. What you just said, we had an investment group that involved Finnish investors and Taiwanese. I don't know, no, Singapore. And so multinational, and they were going to put in a massive salmon facility into our community. Indoor, I mean, this thing looked like you filmed a James Bond in it. Like it was that advanced. And it didn't go through because the townships dug their feet in and said, look, we're willing to give you what you're asking for. Like, in other words, you want more than just, you know, if you have to do a little extra here or there or bring something in from off-site, your money going, we'll give you a certain percentage of that. But we're not going to give you what the investors wanted. It's carte blanche permit that said we can do whatever we want. And so who's to say over those hundreds of acres that we couldn't have 3 more facilities going in 5 years? And it's not that we're against them, but it was a situation of we can't give you carte blanche. So in this case, it's not a right to farm issue. It's really a legalistic zoning issue. Is what was the permit given, and if he's exceeded it, you would have recourse to go back. If he hasn't, or it's not clear, you talk to your attorney and see what you do. On the sale of it, or excuse me, the event bond part, or the event, if that was not allowed as part of the original granting, you could shut that down immediately through your attorney. The problem is you're fighting someone with probably very deep pockets. But you could, you know, legally, they can't be operating that without coming back to you for a permit, number 1. 2, you could shut it down because of that. 3, if I'm a realtor, I would not be marketing it as that because if someone bought it, came in, and then came to the township, and the township says, well, you can't do that, you don't have permission. I don't care what the realtor told you can make Disneyland out of it. They're liable.
Yeah.
I wouldn't do that.
We're not trying to start fights with people.
Yeah.
We want them to know up front. No commercial use is permitted in our ag zone.
Yep.
A handful of grandfathered things that were kind of like, kind of spin-offs from farm and resource.
You can work with and keep under control.
Yeah.
So I think in this case, the crux of your problem at this point, before it even sells, is maybe, you know, having a real heart-to-heart with the planning commission, your administrator, maybe your board, and determining, look, if there's no illegal activity going on, we need to deal with it. And we need to see the original permitting just to make sure we don't overstep our bounds. And if we've got recourse, you may need to get the attorney involved and give a cease and desist on it.
The original permit allowed both the vineyard and the house as one to be used. The house, the vineyard was going to be a little bit of taste testing or
Which is fine, but was there anything for the events?
But no, that changed. The whole event, it wasn't like we were going to have weekly events and all that stuff.
That's not a right environment.
We had a
Yeah.
wine tasting.
And that's fine. That would be
That's
legal
as
if you
far
want,
as-
yeah.
But then he was going to split and keep the vineyards and then sell the house, and the house would be a permanent.
Event.
And you know what I'm saying, this is going to be a.
You can't.
Yeah, we're reasonably comfortable standing where we are with respect to this, but it's, it's similarly, there's a person nearby who raises flowers, and, it went from raising flowers and marketing flowers to now we had some people ask us whether they can have their weddings in our flower garden, and we're gonna be making flower.
The answer to both is very simple. Does the ordinance allow for it? And if it does, what permits are required? And if it doesn't, then the answer is no. It's really that. And then from your standpoint as a community, it's do you have the willpower to follow the written rule of law? Because you may have to get an attorney involved. The problem is if you don't do it, it's going to down the road.
We're pretty studied on this, and we're in the process of beginning a review of our master plan, and we'll do a survey to see if there's any change in the sentiment of the population about what they expect to see in their ag zone. And we try to do it right, but, the danger is, 15 years ago, people started talking about, well, you got this blanket ag thing, that's not so good, isn't there something different that would work? And they started to come up with things like rural recreational. And to me, those are kind of a dangerous door to open with respect to what people could expect to do.
A better way in these types of situations, and I'm going to assume for argument's sake, if you don't want any of these at all, carte blanche, you're silent. If it's something that you want to look at allowing, but in a controlled way that works in your community, like I kind of talked about earlier, maybe the better way is to do it through a special use permit where it's allowed in the district, but we've got very specific rules you have to meet, okay? Maybe, I'm throwing these out randomly, but they don't have to apply to anything. Maybe it has to be on a primary road with sewer and water. It has to be, if it's a barn wedding venue, it has to be set back at least 1,000 feet from the nearest non-farm residence other than maybe the owner's residence or whatever. Put those into play because then you have a ton of control through that special use process. It's not just a use by right where, yep, you can do it, good luck.
We're very careful about what qualifies as use by right.
Yeah. So that would be my best recommendation. And then don't forget too, the first thing is I've seen communities where they do something by special use and it's literally use by right. You just have to pay a fee, go in to the hearing and get, why even do it? You need to have those rules in place that are appropriate. But don't forget, so a standard permit, your zoning administrator, these are the rules, you meet them, you don't, here's your permit. With the special use, you have the ability to look at it and put reasonable conditions. Okay, you can't tell this guy, you know what, you're loaded, if you give us 50,000 for the new park we're building down the road, because you'll probably be in jail for that. But what you can do though is put reasonable conditions. Maybe it's an ingress egress. Keep it on the main road, don't put it up here, or move it 500 feet down the road so it's not at this busy intersection where we're going to have traffic incidents. Or you know what, you look at your site plan, you like what you're proposing, it kind of works here, but you've got 80 acres here, and you're putting this thing 150 feet from the property line, and there's a house another 100 feet in. If you were to move that over 300 feet, we could work with you on this. Those are the things that you have that reasonable discretion to do in those meetings.
Very expensive, hard things in the ground. You're not going to be moving too much.
Yeah.
And it's not just those particular, try to be vague descriptions. Really the essential issue is the noise that would come rolling down the hill. We have family reunions all over the place. That's a different story.
And the problem is it's already there. If it was approved without conditions, you're not going to have a lot of control on that other than doing maybe a separate noise ordinance, like a standalone police car ordinance, where it's broad for the whole community, and if someone operates past 10 o'clock at night or what, then you can go in and deal with it that way. But, ideally, we just actually did a wedding barn. We're actually building a wedding barn in Leelanau County. And one of the conditions, and the gentleman proposed it actually himself, is he's not a big late night guy. A lot of these wedding barns, they happen to take place in the day anyway, usually. But 10 o'clock at night, music is cut off, and then the whole place is cleared out by 11, like the workers and everything. And so that was one of the conditions because it was near a lake area, maybe not so that's early for wedding. But yeah, you got to do it in that process.
Part of the problematic in the language was event venue convention center. That one, they have high hopes for what you might do. Somebody does.
That's how it's being sold in the
That's
last.
the realtors.
Someone, I would have the attorney contact the realtor and see some now. But
We told them.
buyer beware, right? Be careful what you buy, so. Yes, sir.
Has anyone mapped the farms that have gotten the reviews?
No, there's no map of that. They do maintain records, so if you were on a township board and you had a claim on something, you could in theory call one guy and just say, hey, this is the address, have you guys done the certification, have you, compliance? And if the answer is, I mean, they'll be able to pull it up real quick, they've got it in the database, it's just not massive. So,
Have you got any idea in terms of percentage of farmland that has?
it's actually very few because the only thing that usually triggers it is some type of complaint or ticket. Because basically, usually it's going to be going to court, and that's when a farmer goes to review to protect themselves against the claim. Some farms will preemptively do it even without complaints. They'll just get a compliance review. The other thing to know, and this is a side note, but I noticed this guy in Peninsula Township triggered me the other day. Some farms have big white signs, green lettering, NEEP certified. You familiar with that? NEEP certification is an environmental certification. The short thing that you need to know is this. If a farm is NEEP certified, part of that certification means GAMS compliance.
Okay.
So they're already good to go. Now, the only problem though, you gotta be careful with this. So you're a farmer. 5 years ago, someone made a complaint, you got a letter of compliance. It might have only been part of your farm, not the whole thing. Maybe last year you changed your operation and expanded. You would still need a new review of compliance for that. Because just because you're in compliance one day doesn't mean you're in the next day. So, but no, most of these, we're going to court, we better get it done so we can have protection as a judge. Any other questions? I will stick around if anyone has anything else and come up and ask me privately if you need.
Thank you.
Yes,
Thank you, Ryan.
Yes.
The use, special use permit, can you render in that as a contingency? Can that be assigned over?
Give me an example.
Whatever is acquired through the special use permit remains with the person who acquires the permit, can't be transferred to another owner.
So,
My short answer is ask your attorney that. But so if you put a condition, it's only for Bill, not for Bob. My short answer is ask your attorney. I almost am 100% certain the answer is no, because permits go with the land, not with the landowner. The only way you could do something like that is conditional. There's a type of permit that can be granted specifically for a time frame or for use, and then go away.
something restricted, I know that.
If you do that process, the answer is yes, you can. Yeah, but if it's a
Yes.
But if it's a special land use permit, then I believe the answer is no. I would leave that to your attorney for certainty, but I'm very confident in saying you can't do that. I mean, think of a standard permit, use by right permit. I can't give you permission to put a deck on, and then you buy his house 5 years later, remove it. And then you buy it 5 years after that, I'll put a deck on it the same size. I mean, the permit was granted. It's that simple. It's not temporary. So I don't think with a special use you can. I think it's a certain type of conditional permit, you can do that.
You can't limit the time of that special use permit. I know that for a fact.
Yes. There are certain activities you definitely can on a regular basis. Generally speaking, you don't. Generally speaking. But if you were going to go that deep into something, I would definitely consult your attorney to make sure, because I can't give you a blanket answer, and it's not that I don't understand it. It's very specific to the type of permit and the type of use. So one of the good examples is maybe it's a mining operation, grab it. 100%. 100% you can say you got 10 years, this time frame, you're done, restore it, we're over. There are certain types of permits where you allow a tiny house in the middle of a subdivision or a neighborhood, let's say in the city, to become a mom and pop store. But you limit it to very specific uses. It can't become a corporate Rite Aid. It's got to be mom and pop. If they stop doing it, or they sell, or they die, it reverts back to a residential use. There are things where you can do those types of things.
Mineral rights, for example.
Yes. And we actually have, so when we do, and I'm not trying to hedge any on purpose, I'm envisioning in my mind, so we teach citizen planner for like planning and zoning officials, and we have a whole slide, with a big caution sign, and it says, if you're gonna do this type of stuff, you start with your attorney, you work with your attorney, you end with your attorney. Because the nature of it. So I'm not really trying to hedge in on this, and we're talking generalities, and I think, yeah, I'd be careful with that if you're gonna do it. I'm not saying you can't talk to your attorney if you're gonna do something more complex like that. But generally speaking, a permit runs with the land.
I hope people don't go away thinking we're just unduly control freaks, we're really not.
I don't think that at all. I think what I heard from you is, I think what I heard is you've got a couple of instances of what's going on. You don't want it to bear a lot of control. But some of them, the ones that are grandfathered, you work with because they're grandfathered, right? You have some control because they can't expand without permission, and they, conformance issues and all that. But you also have some real legal issues here potentially, and you're fighting deep pockets, which makes it a little harder. But the integrity of the ordinance would demand you enforce it, right? And if you lose, you lose. But I understand you're kind of stuck between a rock and a hard place. I did not hear at all with what you said that we need to regulate this. We need to do what's appropriate for our communities.
We're between the rock and a hard place, we live in paradise.
Thank you.
Yes, sir.
I'm the big farmer that you guys are talking about.
Oh, yeah.
And I want to tell you guys, me and my wife, thank you for the help.
Well, I hope I got the facts of the case right, because I was just going off the summary of the judge.
Thank you very much. We wouldn't want without you.
Thank you all for attending, and for those who are watching online or be watching after today. And thank you, Ryan, that was very informative. I learned a lot as well. So feel free to stick around. There's refreshments here and some snacks. And
Just out of curiosity, do you have a registration list?
Yes.
If you want to, you are more than welcome to send me contact information. I'm not sure if it was on that initial sheet. I know I had a file, but you ever have issues, you give me a call. So,
That's good.
and I can help you out. So,
Okay.
yeah,
Great.
thank you.
Thank you.
Did we ever get them online? Well, we did get them actually with their line. How do you do that?